Mrs. Weaver signed it. So, now you know. There was an endowment, and it disappeared, and it ended up being changed by them. And then, in 2002, once again they wrote to us. On checking our customer contact department, they do not appear to have ever received a written authority for the above. Therefore, your account does unfortunately remain on a part endowment, part repayment. As you can see, if I can put it up correctly, there is the date, 2002, and oh, there's their apology again. So, now, well, it's not an apology, but it's an admission that they've never had any change in the contract from us. So we come to the case. Now, Michael, who assisted me, that's Benicia, he put this in, which is exceptionally, it's actually brilliant. Once I find it, so I'm not too clever then because I've lost it. This is the unfair trading terms contract, 1977. The Unfair Terms in Contracts Act 1977 states in section 10, a person is not bound by any contract term prejudicing or taking away rights of his which has arisen or connected with the performance of another. Another contract, so far as those rights extend to enforcement of another's liabilities, which this part of this Act prevents that other form of excluding or restricting. So, layman's terms, basically, the 1977 Act clearly prescribes the new contractual terms cannot be used by any party to evade the obligations incumbent upon him or her or them under the terms of the preceding bilateral contract, regardless of the nature. I couldn't do it, they can't do it, and they shouldn't have done it. So, they've admitted that those terms and conditions were changed by them, but not by us. And if they force the issue, then it comes to the Law of Provisions, Miscellaneous Act 1989. That Act states that the deed must be signed by both parties. The contract must be signed by both parties with the terms and conditions and all the other parts that go with it to make it a legal binding deed. Without them, you can't use it. As Michael proved in Newcastle when he put this forward for his father and won a remarkable case. It's now case law. So he was and is the highest authority in that. So, once again, they're stuck on that one. So they can't move out of there. Now there's one other one, which I'll bring in. And this is the capitalisation. Now the Bank of Scotland was highly censured because of this. This is the Macready case, and they capitalised the interest. They admitted that not the interest, capitalised any debts. So if we'd gone over payment and they fined us, basically, any movement on that to charge extra money, then put it on in the mortgage again, and then charge us again for it. It's double dipping. So they've been censored for that, the Bank of Scotland. I don't know what the outcome is, but I don't think it's very good. I mean, they lost that case because of that. Right, so now you know they changed the terms and conditions, and they were stuck with the 1977 Act and the 1989 Act, and they capitalised it. Now, what I suggest you bear in mind, let's say this was a criminal case, which is plain and simple. I'll explain it like this. Let's say somebody's crossing a zebra crossing and he gets knocked down by a driver. And the police come along and arrest the driver. And now they can charge him with attempted murder, or if it's accidental, manslaughter. And the man says, could be a woman, I don't know, I didn't mean it. So the police may take that as an admission and charge him with manslaughter. And he'd get a very serious sentence for doing it without care, due and attention, taking a life. And the other one, the murder, would be even more serious and even a longer prison sentence. Once that procedure had gone through in the police station, they would have said, I'll write this down, will you sign this? It's a confession, and they would sign it. So let's say that's an end of the matter. This here is Bradford and Bingley. They've admitted here they've damaged my family. They've changed the terms and the conditions and the contract without our consent, and they say it wasn't their fault, no due care and attention, and they admit it because, oh, that's the wrong one, sorry, that one. And then they they admit it. They sign the confession. But in this case, the victim has been made to pay. So I'll leave you to judge if our case has got any merit. We asked them to bring their books. They didn't. We asked them to bring evidence. They didn't. They brought statements and scratch cards of conversations on the phone which could be made up from anyone. Right, so let me know what you think, if we're guilty or we have no merit, or the bank is guilty and they have no merit. So there's your case. Now, talking about the case, they got a possession order and they applied for it. This is a claim for a possession of our property, and as you can see, there's very little detail there. No seal. Every county court should be a court of record and have a seal. That's an embossed stamp. As you can see, there's no title deeds for the house that they're coming after. That isn't sufficient either. And there's no service address. They have a fee, but no fee stamp to say it's been paid. That isn't worth toilet paper. I could use the toilet paper. That I can only burn. It's nonsense. The Nottingham County Court proceeded with that case. That, I guarantee, came out of the solicitor's offices. Didn't come from the court. It isn't a court document. That is the casement file. That is the DNA of the case. Everything that happens goes into the computer and is registered. As you can see, there was no fee paid. The only fee that was paid in the casement file, I've got many pages, what happened, this is our payments, always registered. There's another one. The first one was £50, that's £135. You can see they do register the payments. I won't go through them all. So we'll come to the final one. The case started and they issued a so-called warrant. It's a forgery. That there states that there was no judgments and there was no warrants, and it is recorded, and that came out a week before I went to court. So, as you can see, this case didn't actually get into court. What it did get into, it got into a shadow court that does not exist. You accept these courts, you go into a little room, and they steal your property. The solicitors don't pay fees. They simply process the so-called claim. I asked them to produce the receipt. Now, the judge said they would have paid online. What that has to do, is he defending them? Is it his job to defend them? Well, they didn't pay online, because if you buy anything off the internet online, you will get a receipt. They'd have to get a receipt to use for tax purposes, to either claim it or to pay it. So I do not think they are telling the truth in the courts or in the solicitors or in the banks. If I'm wrong, why didn't you prove it in court? I've asked many, many, many times for that information, and I got waffle, but I didn't get the receipt. Okay, so that's basically it. That's the case done for now. So I hope you got to grips to most of that. It's I'm sorry it's a bit long-winded. I did cut it right down. We've got more evidence, but I hope that's going to be used in a criminal matter later on. So I do thank everybody once again. I said to a few people, I've run out of, well, actually the tea on my computer is worn out for me thanking people. So my final time on this video, a debt of gratitude is owed to everyone who came every time. Not just this time, but every time. And we've got to grow. We've got to stop this corruption. We've got to protect our people. So, you take care of yourselves now. And thank you. Bye for now.